All rise. The 55th Circuit Court is now in session with the Honorable Roy G. Meek presiding.
You may be seated. Good morning. Calling the case of the People versus Robert Presley. Counsel identify.
Michelle resides for the people.
Gerald White representing Mr. Presley, Your Honor.
And, I don't think we have Mr. Presley here this morning for via Zoom. And trying to forget what we set this up for, but talk about the trial.
Your Honor, may I interject for a moment? This is
Sure.
a unusual situation because prosecuting attorney's office indicated that you were holding court today, and that if I was going to request an adjournment, that this would be a good time to do that, and that's exactly what I'm doing at the present time. Well, let me give the court a little bit of background. I met with Mr. Presley for the first time face-to-face yesterday at the Hanlon Correction Facility in Ionia, and we had a long discussion. And what I'd like to do is to ask for an adjournment for additional preparation in this matter. It's currently scheduled for trial, 4-day trial on July 20. And this is an old case, as the court is well aware. And, but this is my formal request to ask for an adjournment for additional preparation.
About how long of an adjournment do you think is necessary?
Not long, Your Honor.
1 month, 2 months?
2 months. I think 2 months. I was going to say 2 months, but then I think the court can agree with that if that's possible.
All right. Any objection, Ms. Ambrositis?
I have no objection. I would just request that maybe Rhonda coordinate with both Jerry and I to find a date that works best for us in the court, because I do know I have some trainings and other things that are planned out in September. But if we can coordinate, I think we can find a good time that'll work for everybody.
I think the two of you can get a hold of Ms. Reppert and find a date that works. All right.
That'd be fine, Your Honor.
I'll tell her if we have to, we may have to move some other trials because this one's clearly older than most.
Right. I agree.
Okay, perfect. Thank you, Your Honor.
All right. Anything else?
Not for me, Your Honor. Thank you very much for allowing me to interfere with your day.
All right. All right. Thank you. We're in recess.
Thank you.
55th Circuit Court is now in session. The Honorable Roy J. Meek presiding.
You may be seated. On the case of the People versus James Carl Case III. Counsel identified for the record, please.
Michelle presides appearing on that people.
Attorney James Keeble on behalf of Mr. Case. Would you like this at the table or?
Probably at the podium.
Thank you.
You are James Carl Case III?
Yes, sir.
How are we proceeding this morning?
Your Honor, my client will be entering a plea at this morning. We have spoken with the prosecuting attorney and we've reached a resolution.
All right. And to what?
My client will be pleading guilty to count 1 as habitual third, count 2 as habitual third, as well as count 5, and with the recommendation for bottom end of the guidelines.
And how old are you, Mr. Case?
40.
Raise your right hand and be sworn.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Mr. Case, you received a copy of the information and gone over that with your attorney, is that correct?
Yes, sir.
And are you waiving reading of the information for today?
Yes, sir.
And previously you waived preliminary examination, is that correct?
Yes, sir.
Being charged with count 1, controlled substance possession of methamphetamine. That's a felony. It carries a maximum penalty of 10 years in prison and or a $15,000 fine. Unless sentenced to more than 1 year in prison, shall impose license sanctions. What was it, 1, 2, and 5, did you say?
1, 2, and 5.
Count 2 is weapons, firearms, possession by a felon. That's a felony, carries a maximum penalty of 5 years in prison and or a $5,000 fine. Mandatory forfeiture of the weapon. And count 5 is police officer fleeing in the 4th degree. Felony carries a maximum penalty of 2 years in prison and or a $500 fine. And Secretary of State will suspend your license for 1 year. You're also charged as habitual offender third, which means that will double the maximum penalty on those cases. So count one could be 20 years in prison, count two could be 10 years in prison, count five could be 4 years in prison. The minimum on all three counts is discretionary with the court. Do you understand the charges and the possible penalties?
Yes, sir.
Your Honor, there was one other thing I did not mention with regards to the plea. It also will be concurrent to any other sentence that he gets from Gladwin. And he has a pending case here. If he should be sentenced here in that case, it would also be concurrent.
There's one of three possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of three possible pleas you may make?
Yes, sir.
Entering count one, controlled substance, possession of methamphetamine, how do you plead?
Guilty.
Entering count two, weapons, firearms, possession by a felon, how do you plead?
Guilty.
Entering the count five, police officers leading in the fourth degree, how do you plead?
Guilty.
And entering offender third offense notice, how do you plead?
Guilty.
You understand that no one may make any promises for this court as to what your sentence will be.
Yes, sir.
The court further, if pleas are accepted, you will not have a trial of any kind and therefore give up the following rights. She's handing you advice and rights form. You can follow along as I explain them. You'll be given up the right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. You understand these rights?
Yes, sir.
You understand if I plead guilty, you give up each and every one of those rights.
Yes, sir.
All right, go ahead and sign and date that. Ms. Ambrositis, would you put the plea agreement on the record?
Your Honor, return for the defendant's guilty plea to counts 1, 2, and 5 as a habitual third offender. The people would move to dismiss the remainder upon sentencing and running the appropriate appeals period. There is an agreement pursuant to Briggs and Killebrew that this would be a cap at the bottom end of the MDOC determined guidelines. The sentence would be concurrent sentences between the charges in the file and concurrent with the Gladwin County sentence, and concurrent with any probation violation sentence. We would dismiss the remaining counts not pled to upon sentencing in the appropriate appeals period, forfeiture of the firearms and ammunition seized, and forfeiture of any contraband seized.
Hibble, is that your full and complete understanding of the plea agreement?
That is, Your Honor.
Mr. Case, did you hear it was put on the record as a plea agreement?
Yes, sir.
Did you understand it?
Yes, sir.
And are you in agreement with it?
Yes, sir.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No, sir.
Has anybody threatened you or your family in order to induce you to plead guilty?
No, sir.
Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way?
No, sir.
Is it your own personal choice to plead guilty?
Yes, sir.
And are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
Have you understood everything that the court has told you?
Yes, sir.
In light of everything the court has told you, do you still wish to plead guilty?
Yes, sir.
Drawing your attention to on or about May 12th of 2020, were you in Hayes Township, Clark County, Michigan?
Yes, sir.
And at that time, did you have some methamphetamine in your possession?
Yes, sir.
And did you know it was methamphetamine?
Yes, sir.
Did you have any license or prescription to have that in your possession?
No, sir.
And at the time, did you also possess a firearm?
Yes, sir.
And did you have your firearm rights restored at the time?
No, sir.
So you didn't have the right to possess a firearm because you had a previous felony conviction, is that correct?
Yes, sir.
And at the time, were you driving a motor vehicle?
Yes, sir.
And did you receive a visual or audible signal by hand, voice, or emergency light or siren by a police officer driving a police vehicle?
Yes, sir.
And they wanted you to stop, is that correct?
Yes, sir.
And you knew he was acting in the lawful performance of his duties?
Yes, sir.
And did you fail to bring your motor vehicle to a stop?
Yes, sir.
And previously, were you convicted on or about July 14th of 2004 of attempted police officer assaulting, resisting, or obstructing the 55th Circuit Court for Clare County, State of Michigan?
Yes, sir.
And were you also convicted on or about April 1st of 2019 of the offense of possession of methamphetamine in the 55th Circuit Court, Clare County, State of Michigan?
Yes, sir.
Mr. Ambrositis, are you satisfied with the factual basis?
Yes,
Are you satisfied with the factual basis, Mr. Kibble?
I am, Your Honor.
Does the court comply with the court rules, Ms. Ambrositis?
yes,
Does the court comply with the court rules, Mr. Kibble?
It has, Your Honor.
Kibble, you're gonna be available on August 9th at 11 a.m.?
I can do, Your Honor.
All right. We'll set sentencing for August 9th at 11 a.m. Defendant is referred to the Department of Corrections for preparation of a pre-sentence investigation report. Bond is continued. Case is adjourned to the date time set for sentencing. Ms. Medley, any questions or information for Mr. Case?
Mr. Case, if you could come down to the office in the basement, I'll give you your PSI pack.
Okay.
All right.
Thank
Thank you,
you.
Your Honor.
We're in recess.
All rise.
Thank you for squeezing us in. I truly
All rise. 55th Circuit Court is now in session. The Honorable Thomas R. Evans presiding.
Good morning, you may be seated. Calling the two cases of People versus Joshua L. William Carlton, file numbers 18-5964-FH and 20-8308-FH. Would counsel identify for the record, please?
Your Honor, Karen Tomczyk for Mr. Carlton. I do know that there was, I believe, a bench warrant issued in file 21-6565 FH for Mr. Carlton based on kind of the same set of circumstances. I just want to make sure that we can clear everything up today.
All right, well, let's round up that file as well. The 2021 file, is that a probation violation matter, or is that a matter that will require the prosecuting attorney to participate, Ms. Tomczyk?
That would need a prosecuting attorney, Your Honor.
All right, I see Agent Rebecca Medley is present via Zoom, as is the defendant, as are you, Ms. Tomczyk. But we don't have anyone from the prosecutor's office. So I'll take a break. I will ask the clerk to fax to us a copy of the information or amended information in the 2021 file, and then we'll proceed a little bit later. Thank you for being here. We'll be in recess.
All rise.
Okay, thank you.
Calling the three cases of people, well, first, good morning, you may be seated. Calling the three cases of People versus Joshua L. William Carlton, file numbers 18-59-64-FH and file 20-6308-FH and file 21-6565-FH. Would counsel identify for the record, please?
Thank you, Your Honor.
On behalf of the people.
Thank you, Your Honor. Karen Tomczyk on behalf of Mr. Carlton.
And Agent Rebecca Medley also appears on behalf of the Michigan Department of Corrections and the Clare County Circuit Court Probation Department. Mr. Carlton, would you please raise your right hand to be sworn, sir?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
Could you tell us your name, sir?
My name,
Yes, sir.
Joshua L. William Carlton.
You may be seated if you'd like, Mr. Carlton. Mr. Carlton, you appear here today to be arraigned on pending felony charges in the 2021 file, and also to be arraigned on pending probation violation charges in the 2018 and 2020 file, and also, if need be, to be arraigned on the charges in those two files, 2018 and 2020 files, for alleged criminal contempt of court for failing to appear in court previously in those two files as ordered. How are we proceeding regarding the 2021 file, Ms. Tomczyk?
Your Honor,
Go ahead, ma'am.
Mr. Carlton has already been arraigned in that file, but we would waive reading. My understanding is that we do have a miscellaneous hearing set for July 19th. I do see that
That's
there's.
right, ma'am, we do. I'm sorry, we do have a hearing scheduled for July 19. That matter is, we're fully prepared to proceed on July 19. I was under the mistaken impression, apparently, that you wanted to resolve the 2021 file today via a plea of guilty to one or more of the counts in the file. Was I mistaken in that understanding?
Yes, Your Honor. My understanding was
All right.
that Mr. Carlton did not appear for court on the 21st, on June 21st, and that bench warrants were issued in all files.
All right, miss, I think you are correct. Thank you, Ms. Tomczyk. Very well, that matter will proceed to a hearing or a status conference on July 19th as scheduled. With regard to the 2018 and 2020 files, how did you want to proceed in those two matters regarding the probation violation charges? Is there any sort of plea agreement worked out vis-a-vis the actual charges for the probation violation matters, Ms. Tomczyk?
Not at this time, Your Honor. We are very close to a resolution, and I believe that this matter will be resolved on the 19th. We would just like to address the bench warrant for the failure to appear on the 21st.
All right, the probation The 2018 and 2020 files will be scheduled for a status conference to occur on
Do you want to put them with the number?
Monday, July 19, at the same time as the 2021 file. And then with regard to the, in the 2018 and 2020 files, apparently the court previously had issued a bench warrant, or actually the defendant allegedly failed to appear in court as ordered previously in that file, back on, in those two files, back on June 21 of 2021, at which point in time I believe the court scheduled those matters also to be for a status conference on July 19 of 2021. Is that correct, Ms. Tomczyk?
Yes, it is, Your Honor.
All right, so why are we here today then, ma'am?
Well, Your Honor, I think that the court had issued a bench warrant for Mr. Carlton's failure to appear on the 21st. And we would just ask that the court reinstate Mr. Carlton's bond as he is.
I'm sure you would, ma'am. I'm sorry, go ahead. I don't mean to be snide. I'm sure you would ask for that, but go ahead, ma'am.
Your Honor, I would let the court know that Mr. Carlton is the only support for his family. He has been working 12-hour days since he has been had made bond. And I would note to the court that this was his first non-appearance. He is a client that keeps relatively good contact with my office, Your Honor. So again, I would ask that the court reinstate his bond and have these matters set for July 19th, when I do see a very good possibility of a resolution on all three cases.
Do the people have any position in this matter, Mr. Webb?
Your Honor, I've been speaking with the probation department about this case. It's my understanding their recommendation is going to be for a prison term. So I think bond is appropriate as it's set now.
All right. Since the only matter before the court, since all of these matters are currently, when I say all of these matters, in the 2018 and 2020 files, as well as in the 2021 files, each one of those matters is scheduled for a show cause hearing to be conducted on July 19, 2021 at 10 a.m. As to why the defendant should not be held in criminal contempt of court for allegedly failing to appear in court as ordered back on June 21 of 2021. Those matters all are scheduled for July 19 in any event. And since apparently the only thing before the court in these files today is in the 2018 and 2020 files, in which apparently the court has issued probation violation charges, and attendant to the probation violation charges, the court had set bond in each file in the amount of $5,000, cash only, to be posted only in the defendant's own name. However, that bond appears to be separate and apart from the defendant's alleged failure to appear in court on June 21 of 2021. The probation department, through the prosecuting attorney, has opined that in the event the defendant is found guilty of the probation violation charges, some or all of those charges, that the probation department envisions recommending a prison sentence, at least at this point in time. And of course, the court is fully aware that the defendant is presumed to be innocent of the 10 probation violation counts that have been filed in each one of these two files, unless and until the probation department proves by a simple preponderance of the evidence, i.e. that it's more likely than not that the defendant committed these crimes or these probation violation charges. Unless and until that happens, the defendant is presumed to be innocent. Why is it, Ms. Tomczyk, that you believe a bond is not appropriately set in the 2018 and 2020 files, ma'am?
Your Honor, I was asking that the court reinstate the previous bond in those files, and I would note that Mr. Carlton had appeared for all prior court hearings prior to the 21st. That was his first non-appearance, Your Honor.
All right, it's my understanding, and I could be in error, but it's my understanding that with regard to the 2018 and 2021 files, that the court did not cancel the bond. Specifically, I'm looking at the case register of actions for the 2018-5964-FH file, wherein it indicates on June 21, 2021, quote, bond continued, notice sent for 7/19/21 at 10 a.m., miscellaneous hearing, failure to appear scheduled, defendant must appear in person, close quote. It appears to the court that I never did cancel the bond in that 2018 file. Similarly, in file 20-6308-FH,
Honor, I guess I apologize. I'm looking here now. It looks like the court signed an amended probation violation, adding additional counts 6 through 10.
I believe you are correct, Ms. Tomczyk. No apology, of course, is needed because these are somewhat confusing cases, but it appears to me that back that in the 2018 and 2020 files, in the 2018 file on June 4, 2021, the court filed an amended probation violation charging document, adding counts 6, 7, 8, 9, and 10, and setting bond in that as to that amended probation violation matter in the amount of $5,000 cash only to be posted only in the defendant's own name. And the court does note that the previous charges, counts 1, 2, 3, 4, and 5 in that file, all related to an alleged incident on January 8th of 2021, wherein in count 1 as alleged, the defendant allegedly violated state law by attempting to furnish contraband to a prisoner. Count 2, that he allegedly violated state law by attempting to deliver the controlled substance Suboxone. Count 3, that he violated state law by allegedly possessing the controlled substance Suboxone. And then also, according to count 4, on January 8th of 2021, that he allegedly violated state law by operating a motor vehicle on a suspended license. And then in count 5, that on January 8th of 2021, that he possessed the controlled substance Suboxone, and that was charged as being a violation not only of state law, but in count 5, that he had allegedly violated special condition 2.4 of his probation order. A similar count 1, 2, 3, 4, and 5 had also been filed in file 20-6308-FH. Those are all relatively minor offenses. Then, on or about May 12 of 2021, in the 2018 and 2020 files, the court filed an amended probation violation charging document setting forth counts 1, 2, 3, 4, and 5, as the court already has covered on the record here today, and also adding in each file counts 6, 7, 8, 9, and 10. And with regard to counts 6, 7, 8, 9, and 10, those matters appear in some ways to be more serious. Count 6 in each of the 2 files alleges the defendant violated special condition 2.4, which required that he must not use or possess any controlled substances, and specifically it's further alleged in count 6 in each of the 2 files that on April 21, 2021, the defendant tested positive for methamphetamine in his body. Count 7 in each of the 2 files alleges that the defendant violated Rule 10, Special Condition 2.4 of his probation order, which required, of course, that he not use or possess any controlled substance. And specifically, it's alleged in count 7 in each of the 2 files that on or about April 21 of 2021, the defendant tested positive for amphetamines in his body. Count 8 in each of the 2 files alleges that the defendant violated rule number 1 of his probation order, which required that he must not violate any criminal law of any unit of government. And specifically, it's further alleged in count 8 in each of the 2 files that on or about May 11 of 2021, the defendant violated state law by leaving the scene of a property damage accident. Count 9 in each one of the 2 files alleges that the defendant violated rule number 1 of the probation order in each file, which required that he must not violate any law, any criminal law of any unit of government. And specifically, it's further alleged in count 9 in each one of the 2 files that back on or about May 11 of 2021, the defendant violated state law by operating a motor vehicle while his driver's license was suspended. And then according to count 10 in each one of the 2 files, it is alleged that the defendant did violate Rule 27 Special Condition 4.25 of the probation order, which required that the defendant must report any arrest or police conduct within 24 hours of the contact to the probation agent. And further, it's specifically alleged in count 10 in each one of the two files, the 2018 and 2020 files, that in that on or about May 11, 2021, you had police contact and failed to report this within 24 hours to your agent. Those are the new charges that were brought, or those were the amended probation violation charges that were in each one of these two files, the 2018 and 2020 files. And then, as Ms. Tomczyk pointed out, because there were now new charges being added, and because some of the alleged conduct was more severe than the earlier conduct alleged in the original counts 1, 2, 3, 4, and 5 in the two files, the court imposed a higher bond in each one of those two cases, and the court set bond in the 2018 and 2020 files at $5,000 cash only, to be posted only in the defendant's own name. So, with regard to the original bonds that were set in the 2018 and 2020 files, those bonds have remained in effect, and the court will be addressing that situation on July 19 of 2021. With regard to the 2021 file, the court will be addressing that the bond in that matter, bond has been continued in that matter, and the court will address the issue of bond in the 2021 file on July 19 of 2021 as well. The only thing new that we're here today is that the court has set bond, a new bond on the amended probation violation charges in the 2018 and 2020 files, and that new bond in each one of those files has been set in the amount of $5,000, cash only, to be posted only in the defendant's own name. So my query to you, my question to Ms. Tomczyk is, the prosecutor has weighed in and said that from the people's point of view and the probation agent's point of view, he believes those new bonds of $5,000 are appropriate in light of the alleged violations set forth in counts 6, 7, 8, 9, and 10 in the 2018 and 2020 files, including as a factor in that opinion that the probation department is of a mind, if the defendant is found guilty of violating his probation, that they will be recommending a prison sentence in the 2018, 2020 files. You apparently or impliedly seem to think the bond should not be set at $5,000 cash only, be posted only in the defendant's own name in each of those two files. And my question to you, ma'am, is A, why do you think that? And B, what is it that you propose the bond be set at in each of those two files?
Your Honor, in speaking with my client, he is obviously, again, he is the sole earner for his family. He does have a disabled child with severe medical issues that he supports, that his wife has to stay home full-time with that child. He does not have the amount of money to post for that, and we would ask that the court consider a personal recognizance bond. This is the first time I'm hearing that the department is changing their recommendation to a prison recommendation.
All right. Well, in some ways, that might be a moot point, because at the moment, the defendant is presumed to be innocent of these 10 probation violation charges with which he's been charged in the 2018 and 2020 files. And in any event, the court finds bond is appropriately set as to each of those files, and further, the court specifically finds that a personal recognizance bond would not be reasonable as to either the 2018 or 2020 files. So therefore, the motion to reduce bond in those 2 files is denied, and the cases will proceed. All 3 of the cases will proceed to a status conference on July 19, 2021. Thank you for being here, Ms. Tomczyk. Thank you for being here, Mr. Carlton.
Thank you.
Anything further, Ms. Carlton? Or I'm sorry, anything further, Ms. Tomczyk?
No, Your Honor.
Anything further, Mr. Webb?
No, thank you, Your Honor.
Or anything further, Ms. Medley?
Yes, Your Honor, I just wanted to put on the record that Mr. Carlton has also failed to comply with supervision while out on bond. So there will be another amended violation on the 18 and 20 cases.
Thank you, ma'am. We'll be in recess then.
Thank you, Your
All
Honor.
rise.
Thank you.
Court is in recess.